part of these rules, there's always a chapter on written memorials. For this particular Moot, you need to look at chapter 4 of the official privacy Moot competition rules 2023. Get familiar with it and make sure that by the time you submit your memorial, it's fully compliant. As I go along in my presentation, I'll keep pointing out a couple of provisions within the rules that you might have to pay attention to. So you have signed up for the Moot. Your team has been registered. You have received the problem question. Where do you start from to write your memorial? As I mentioned already, start with the rules. Read chapter 4, internalize it, take notes so that you have it at the back of your mind as you embark on your memorial. Then look at the problem question. Council Alan Chigozi has been kind enough to point out for you the background to the memorial, to the problem question, tell you that some of the issues that they are looking out for are on data privacy, surveillance, and state power. So as you're reading the problem question, open your mind up. Try and identify what the catchy things are within the question, where you might encounter a problem either as an applicant or a respondent, and just keep underlining, get familiar with the problem question, get familiar with the names of the people, of locations, geopolitical things that are in there about the country, get familiar with the question. Then, usually the Secretariat of any moot court competition will avail you with legal materials. Collect all of those legal materials and peruse them. Pay close attention to where the court before which you are. Are you before a court? Are you before a tribunal? What are the modalities within that court? What are the applicable laws? What are persuasive laws? Which ones are binding? And have them all noted down and look at those. You will have to refer to those as your primary sources of law. So a memorial takes a particular structure for each moot court competition. There are many competitions out there, and perhaps some of the mooters or even the coaches have taken part in different moot court competitions. I would like you to avoid the temptation to copy a memorial structure from another moot court competition. Stick to the structure that's provided for in chapter 4 of the rules of this competition. So I'm going to go through those rules and just enunciate on what, based on my experience in memorial writing, I will just enunciate on what is expected in each of those. So your first page will be the cover page. In the cover page, you will have the moot competition title. You will have your team code number. Do not write your university's name. Do not write your individual names. Only write your code number. Let's say your code number is 101. Just write that. Which role are you arguing? Then include that you are an applicant or a respondent. And Article 22B requires you to color code it accordingly. So be sure to color code so that it's easier for the judges to identify which role you are arguing for. So that's your first page. Your next page should have your table of contents. Now, if you have done any form of legal writing, you will know what a table of contents is. It's a page that's supposed to list all the sections within your research, plus the attendant page numbers where those sections can be found. And it's supposed to aid whoever is reading your document or the judges to easily navigate it, to be able to jump to the section on whatever issue. Maybe they want to read particularly on issue 3. They should be able to just refer to your table of contents and jump there quickly. You can have an automated table of contents so that it's much easier for the judges when they are interacting with your document. Now, creating a table of contents, depending on how familiar you are with Microsoft Word, may prove a bit problematic. And it's okay if it's your first time to encounter it and have to create one. If it's your first time, get in touch with a friend, a colleague who is more familiar with Microsoft Word to help you. This table of content will be generated at the end, after you have written the main body because then you will be able to, make the references, the page references. It will be much faster so that you don't do double work. So the third section of your memorial should have the list of abbreviations. And that's exactly the title of that section, list of abbreviations. Here, you're going to list all the abbreviations that you have used in your memorial. I mean, every abbreviation. So whether you have used UN and you think, every adult should know what UN stands for, but include what it means. UN stands for United Nations. EAC stands for East African Community. Include also those abbreviations that are generated from the problem question. Your problem question has the NSC, which is the National Security Council. Include all of that. So, knowing what is supposed to fall under this, I'm sure you have already concluded that you're only generating this at the end of after you have written your main argument. That is when you come through and pick out all of the abbreviations that you have used. A list of abbreviations section is supposed to help the reader easily easily understand your writings and to minimize confusion, So some people will, instead of ESC, will write EA to mean East African Community. And it can be disturbing because most of us know it as the ESC. So if you have used EA instead of ESC, well, then just describe what EA means for the reader. Make sure it's comprehensive. Do not leave anything out. Really come through. And also make sure that it is in alphabetical order. It just looks smarter. There is an action after you have listed everything. There's an action on your Microsoft Word that can alphabetize any list of words. The fourth part of your memorial is the index of authorities, which is also, some people refer to it as the list of sources. And you can refer to those provisions of the rules, Article 21 and also Article 23D. So the list of sources is supposed to include only the authorities that you have referred to in your footnotes. It's supposed to give someone an idea of what your sources, what your authorities are all through your text. Avoid the temptation to include authorities just to beef up your list. After you have written your document and you try to generate the list of sources, you might end up with only 5, and it just looks miserable that you have undertaken all of this effort and you only have 5 references. So you might end up getting the temptation to now include 5 others just, even if you haven't referred to them in your submission. Do not do that. Include only what you have referred to in your submissions, only what is in your footnotes. And so also that you can only collect that list after you are done with the main body of your Moot Court competition. I'm sure you've noticed the first part, with the main body of your memorial. I'm sure you've noticed that the first parts of any memorial are really, I don't know what they call them. They are curtain raisers to the main written submission. Now, when you're listing your authorities, set them in full. Use the full reference. So you see the examples that I have written there. If you're referring to the treaty, to the East African Treaty, do not say East African Treaty, no. Write the full name of the treaty. Treaty for the Establishment of the East African Community, 99, as amended on those dates. Do not just write East African Treaty. Say you are referring to this article. It's like one of the fundamental writings on the right to privacy. If you're referring to that article, the right to privacy, write its full citation in accordance with whatever citation style you have chosen. Part of your index of authorities, you will find that you have different forms of sources of law. My advice is that you categorize your index of authority according to the hierarchy of laws. Remember at the start, I mentioned be aware of what court you're before. So you're before the High Court. If you have attended even just the first week of law school, you know what the hierarchy of laws is. So start with the Constitution, Then after that, have like a subheading for acts of parliament you referred to. Write those acts of parliament in alphabetical order. Then have another section for international conventions and treaties that you referred to, subsection, and then list those treaties in their full form in alphabetical order. Then case law. If you want to categorize it according to country, go ahead, but have it alphabetized. Then journal articles and also other sources that you may have referred to, UN resolutions, UN guidelines, handbooks, etc. As you are writing, as you are stating these authorities, state the pages at which you made reference to them. So I've given you that example. Say for the East African Treaty, you write it in full as it's in there. And then at the end, you write page 5 and 9 indicate that you have referred to this treaty on pages 5 and 9 of your submission. The next part of your memorial is the statement of facts. You might wonder why. After all, the Secretariat is the one that gave you the problem question. Why should they anyway require you to have a statement of facts? Well, the rules require it. But also, usually in a moot court competition, one of the things that are judged is your knowledge of the fact. So this part of your memorial is one of the ways the judge gets to evaluate your knowledge of the fact. This section is a summary of the facts. You're supposed to just give a summary of the facts in the problem. Do not reproduce the facts. Do not even reproduce a line as it is in the problem question. Do not make it unnecessarily long. 1 page is more than enough. If you can even make it shorter, the better. So you'll be arguing 2 sides. You'll be arguing as an applicant and as a respondent. When you read the problem question, you realize that there are some facts that are more favorable to one side. So customize your facts to the role that you are arguing. Present your facts in a biased manner to the role that you are arguing. But be careful not to start making your arguments already. Be careful not to try and elaborate on the facts. Just state them. It's just what exactly happened. You're just
Councillor Juliana, we lost you there. Councillor Juliana, we lost you. Hello, Councillor Juliana. Yeah, Councillor Juliana, we lost you. Yeah, we lost Councillor Juliana there as she makes her way back. I'd like to encourage you, the Mooters, to download the resources from the website.
When are you getting back for this?
Yes, Councillor Elijah, you want to say something? Yes, for the meantime, I was saying the Mooters, let us download the resources from the website to help us as we prepare our memorials. I'm sure our council, yeah, she's here.
Sorry.
Okay, you're welcome.
Sorry, I had a problem with my internet connection. Just either maybe for your guidance, how far had I gone before the network went off? The issues, can I start from the issues?
Yes, start from the issues. Yes, start from the issues.
Okay. Let me just share my screen again. Okay. So previously I was talking about, before going on to the issues, I had been talking about the statement of facts. So after the statement of facts, then you go to your issues. And those are the questions that are to be answered, the questions of law and questions of fact that are to be answered. When you look at paragraph 17 and 18 of your problem question, the framers of the question stated for you the questions that are to be answered. So keep with that language, the language that is used in there. You may identify another question of law, but try not to make it an independent issue. Instead, find where you can fit it into and make it perhaps one of your sub-arguments. If there are questions on jurisdiction and admissibility, start with those questions because those are preliminary points of law that need to be resolved. When you look at the rules of the competition, there is actually guidance to the judges on how to deal with preliminary questions of law that may arise. And if I'm not mistaken, if perhaps the objection is successful, then the opposing team wins. The opposing team ends up losing a mark, if I'm not mistaken. So start with whatever preliminary question that may be there. Next is your summary of arguments. Now, this is, in my experience, this was the trickiest part of the memorial to come up with. A summary of arguments is supposed to be a substantive summary of your main arguments on each issue. A substantive summary, but not a reproduction of your main arguments. So your issue one, in my examples, I'm going to keep away from the problem question because I may end up just giving you the answers, which would be unfair and against the spirit of the moot. So your issue one, perhaps your issue one is on whether the case is admissible before the court. And maybe you have two sub-arguments under there. So write that you are, write issue one, then you state what your summary argument is, and that is generated from your main argument. Write your summary argument, what it is for your first sub-argument, and then your second sub-argument. I don't know if that's making sense. You will only be able to come up with these summary of arguments after you've written your main arguments. Again, it's also it's another curtain raiser to the main body of your memorials. Let me give you an example that I got from the Philip C. Jessup Moot, a memorial that was the winner from the University of Pennsylvania. It was the winning memorial in that year. So this was their substantive summary of their argument on whether the ICJ, the International Court of Justice, had jurisdiction over the case. The court may not exercise jurisdiction over Ranulf-Steyer's counterclaim that Aprepluia, those complicated names are the names of the states in the question. The court may not exercise jurisdiction over Ranulf-Steyer's counterclaim that Aprepluia violated international law by shooting down the Maintien Airways aircraft. Pursuant to Article 36(2) of the ICJ statute, Aprepluia's declaration to the court's jurisdiction contains a reservation which is enforceable and covers this counterclaim. So that was their first head of argument under the question of jurisdiction. Here, what they have done is they have stated what their position is in the first line. They have stated the law on which they are referring to and given a slight enunciation of their argument. So you see, their summary is not long. It's not long, and that was just, they had more than one sub-argument. They had about 3 sub-arguments under that individual issue. Then you can move on to the next. Be mindful that your summary of arguments are at least a paragraph long. You can't just write one line and leave it at that. Make it at least a paragraph long. So now we get to part 8, which is the meat of the memorial, the gist of the memorial, your written arguments or your submissions. Here, imagine, most of us, when we are preparing for a moot, we look at the oral arguments. Here, you are looking at what you would have said in your oral arguments, but putting it in writing. So you're going to be mindful of your tense, you're going to be mindful of the words that you are using so that they are more suitable for writing and not for, speech. When you're writing your oral arguments with each issue, you can use this formula to help you guide on whether you are enunciating your issue well. First, agree as a team, what is the issue that we are addressing? Once you have that down, what is the law that we are relying on? When you've stated all the laws you're relying on, this portion of the Constitution, this convention, this act of parliament, this case, this contemporary situation, categorize your list of authorities, categorize your authorities based on the hierarchy as per the culture before. Then after that, make an analysis. So given that this is the issue and this is the law that we are referring to, what part of the facts support our argument? Now pull out those parts of the facts and tie them together with the law. That is what is contained in the analysis, or what other people may refer to as the application. Tie that so well. In this section of your argument, this is when you try and persuade the court to see your reasoning. This is when you paint the picture clearly as to why your argument should succeed. Then after that, make a conclusion, your final position of the matter, and what you would like court to do for you in that regard. So follow the ILAC formula. Be mindful of it. Or after you have written your submissions, go through issue by issue and try and see if it's meeting the ILAC formula. When you follow this formula, you will notice that it's clearer. It's clear, you're not repeating yourself, and it's easier for anyone to understand. There are some general rules that you need to observe when you're writing your submissions, especially in the submission stroke written argument section of your memorials. One, use short and precise sentences. Avoid winding sentences. If you write something and you notice that it could be open to more than one interpretation, redo that sentence. If you use a word and you know that this word could be interpreted in more than one way, and then redo. Find a synonym for that word that is clearer. Use simple English. There's a temptation in legal writing to use Latin because, some principles, when they came up in common law or wherever, they came in their Latin form, etc. But all of these Latin phrases have English equivalents. So avoid using Latin. Only use it if you must. After all, the language of the competition is English. And use simple English. Do not unnecessarily use, what are those words lawyers like to use a lot? Wherefore, really just use normal English. A tip for you, after you've written your memorial, ask a non-lawyer to read it. My constitutional law lecturer used to call it the grandmother test. Give it to someone who is not a legal practitioner. Let them read and ask them if it makes logical sense. If they are asking you too many questions, know that there is something off with the language that you've used, and you're not as logical as you assumed. Support each submission with a legal authority. This is a legal competition. This is a legal submission. You cannot make submissions based on belief. You cannot make submissions based on fanciful thinking. Refer to an authority. And those are the authorities we are looking at. We're looking at acts of parliament. We're looking at treaties to which the country is a party, or treaties that have formed part of customary international law. We're looking at case law, journal articles from respectable publishing, UN general comments, and if you must, contemporary examples. Now, contemporary examples are excellent, especially in oral submissions. And my colleague Brian will speak on that. But if you're referring to a contemporary example, please pick a respectable source. We are not going to make a reference to someone's Twitter handle. We are not going to make a reference to a tabloid to give the example. Say if you wanted to give a contemporary example from Uganda, then look at the main publishing newspapers, Daily Monitor or New Vision, but do not start referring us to procure newspapers whose journalistic position is not well established. Then avoid plagiarism. Avoid plagiarism. Do not pass off another person's opinion as your own. That is what plagiarism is. There's a temptation with mooters to pick up a sentence or even two from a journal article, insert it in your memorial, and because it just sounds too perfect, you leave it there and do not cite whoever the author is. Please avoid plagiarism. Plagiarism is such a grave crime under any moot court competition that you could be disqualified. Then make use of the footnotes. Footnote everything that you need to footnote and adopt a consistent format of referencing. Article 23 leaves you the option to choose what type of referencing you want to use, but make it consistent. Do not on page 1 use Harvard style, then on the next page you're using Oxford style. No, find one footnoting style, referencing style that is easy for you and stick to it. Remember that your written memorials will be graded, and they'll be graded on your knowledge of the law and legal principles, your knowledge of facts, organization structure and analysis, the authorities you've used, persuasiveness, ingenuity, logic and reasoning, your grammar style and clarity. So pay attention to all of those things and try to fetch as many marks from those areas. Article 24 can guide you on how the grading will go. The objectives of the moot court competition have been shared, and you need to be mindful of them. This competition is designed to enrich your understanding of data protection and privacy laws, and also create an awareness of these laws among young lawyers. And it has also been enunciated upon earlier on by Isaac that this bootcamp is supposed to give you training in legal research methods and also empower you to be able to advance any legal arguments. Now, the objectives of the competition should guide you as you're making your persuasive arguments. Your persuasive arguments should not try and counter the spirit of the competition. My time is fast spent, so I'll try and run quickly through the others. Make your prayers at the end of the memorial. State them clearly that you would like the court to do for you 1, 2, 3, 4, 5 things. And all of those prayers should be couched in law, should be supported in law. Do not make prayers that the court does not have power to grant. And also do not make prayers that are not a logical outflow from your arguments. The rules provide for an annex, and this is an optional thing that you may choose to take on. Look at Article 21. In there, it shouldn't be longer than 2 pages. Now, what is an annex? That is like an independent document in itself that you attach at the end of any research writing. And it's something that can be cited on its own. If you have an annex, make sure that that annex is referred to in your main submission. My advice, unless you must, try and avoid having an annex. There might not necessarily be a need. But if you decide as a team to, remember the rules and remember that those 2 pages are coming out of your 10-page limit. At the end of your memorial, you have a back cover, which is just an empty page marking the end of the document. Here are a few points for you to note in your memorial. Memorials usually, in case the oral rounds are too close to call, memorials usually are the title decider. So if you have a bad memorial and you make it far, it will come back to bite you at the end of the competition. So take note of the penalties under the rules of the competition and make sure you don't fall victim of any of the penalties, because they will be enforced. Take note of the font style you're supposed to use, the size, the font size, spacing. They're all stated in Article 18 and 19 of the rules. Do not reveal your team's identity. Only use your code number. Even when you're participating in the oral round, only use your code number, your team code number. Remember, you have 10 pages within which you should include the following: the statement of facts. So that's when the 10 pages start running. The statement of facts, the issues, the summary of arguments, the written arguments, stroke submissions, and your annex, if any. So number your pages. Again, familiarize yourself with Microsoft Word. Ideally, the pages before the statement of facts should have Roman numerals or a different style of numbering. And then starting with a statement of facts, that's when you start to use page 1, 2, 3 up to 10. So that way it's easier even for the judge to see that to judge whether you have fallen within the page restrictions or not. Comb through, after you're done with your memorial, comb through, sit as a team and comb through the grammar, the footnotes, the rules, etc. before you submit. You have a lot of time and all of this is doable. You have until 30th June, before the end of 30th June, to submit your memorials. So do not be in a hurry. Give this as much time as possible. I would advise that you put off 2 weeks just for combing through and re-editing your memorials. Thank you very much.
Wow, wow, wow. Thank you so much, Council Juliana there for that presentation about the memorial writing. I'm sure the Moot has taken notes together with the other Law Society communities. It's time for the Q&A now. The first question here that came in tells us to kindly re-echo whether a contemporary situation can be an authority, because Juliana, you mentioned it. So somebody wants an answer for that. You re-echo on whether an authority can be, a contemporary situation can be an authority.
So, yes, a contemporary situation can be an authority. However, it's not the primary authority. So remember the hierarchy of laws. You definitely have provisions under acts of parliament, under treaties, under the constitution that you can rely on before you get to the contemporary situation. My advice, use the contemporary situation as a way of persuading the court towards your argument. So it's like, so after you have stated all the law, as you're trying to tie it well together, maybe you're using the contemporary situation to warn the court of what evil may follow if they do not side with you, or if they do not enforce whatever provision of the law you're referring to, or you're using the contemporary situation to demonstrate to court that the threat of this right is actually real and it's not perceived, for example, in this situation. That is how you're using the contemporary situation. It's not your first authority. It is more at the tail end to make your argument more persuasive. I hope that's clear.
Right, thank you so much. Somebody is saying more hint on the summary argument. I'm sure this is where somebody is asking about more hint on a summary argument.
Okay. So
I don't know whether, okay.
Sorry.
Then
okay, let me take two and then
that's Leo Gracias in Kutu is seeking for more hint on the summary argument.
Okay, so the summary of arguments. The summary of arguments is so after you have made your arguments under each of the issues, you try and summarize them so that anyone who is reading your memorial can get a snapshot of what you intend to argue in your main body. Think of it like that. So you remember in secondary school, English papers, there was a part on summary writing. So it's essentially that, but for your main argument. Think of it like that. Make them substantive enough, but do not capture the entirety of your main argument. Make sure your summary of arguments highlights which laws you're going to refer to. You can leave out the contemporary situations and save that for later. Just point out the main laws that you're going to refer to. Make one sentence on what your exact position is and a conclusion. So you're sort of adopting the ILAC formula, but in a much more summarized version. I do not know how much more Deo Gracious would like me to enunciate, but I can share. Let me just repost that part of my screen. Maybe he can take a screenshot of it. There's a reference there. There's an HTTP reference there that he can look at to get a clearer idea of what it
thank you. Yeah, thank you so much, Councillor Juliana. Related to that, somebody is asking whether they can refer to websites of reputable news or TV stations, such as BBC, Voice of Africa, among others.
Yes, they can.
Okay, that's very good. Somebody else is talking about...
But make sure that the link you're referring to is still active.
Okay, thank you so much there. Our time is fast spent. Somebody asked whether we can share this PDF. We'll definitely share some notes for you regarding this presentation. Somebody else was asking where to get the rules, a copy of these rules for the competition. Please go to the website of the Moot. You'll have these rules clearly. That is privatemoot.com, uwmoot.com. And then can we quote the Constitution of Uganda as an authority in either the written or oral submission? Councillor Gian, there is one there. Can we quote the Constitution of Uganda as an authority, either oral or written?
But pay attention to your problem question. Your problem question only made reference to the chapter on rights and freedoms, on chapter 4 of the Constitution. That's what is similar to the country of Uganda.
Okay.
So do not start citing for us the chapter on legislative making, etc.
All right, I can see. Okay, Florencia, do we write it after the entire thing or immediately after? So in the interest of time, I want to propose that let the questions keep coming in the chat section. We'll keep typing the answers for you, but permit us to go to our next presentation so that we are able to accomplish our scope for the day. Right now, permit me to invite Councillor Brian to take us through the art of oral presentation. One more time, thank you so much, Councillor Juliana, for that wonderful presentation.
You're welcome.
Yeah. Councillor Brian, you're welcome. Councillor Juliana will keep responding to some of the questions that are in the chat session as we proceed with Councillor Brian. Councillor Brian, you're most welcome.
Thank you very much. I will just briefly try to share my screen so that we get into the presentation.
As Councillor Brian shares his screen, please keep sending the questions to the chat section. Councillor Juliana will respond so that you're able to get that good understanding.
Can my screen be seen right now?
It's loading. Yeah, you're finally here. We are able to view your screen, Councillor Brian.
You can
Hello,
see
Councillor
now?
Brian. We're able to see your screen.
All right. Thank you very much. Thank you, Isaac, and thank you, Juliana, for the session before. My name is Chida Brian Alex YB, and I am with the SOC initiative in this capacity today, wherein, amongst other things, under our law and advocacy program, we do training around Moot Court, all the aspects there too. And we're happy to be here today to facilitate some of the sessions. I will be speaking to the aspect of oral presentation, particularly now that we are done with the memorial writing session. To get into it, yes, I thought it very important to note a few things. As you can see, I start off my presentation by just saying that only the prepared speaker deserves to be confident. And that is a quote by Dale Carnegie. And why I bring it out is just to reiterate the imperative of us preparing, and preparation, as has been stated, really starts with forming.
Council Brand, do you want to make your slide show? Do you want to do a slideshow for this to have a good visual?
Can you see it now?
Okay, let's proceed.
Do you see it on full screen now, Isaac?
Not yet, probably it's loading. To help us get a slightly better visual.
We'll proceed.
Yeah,
Okay.
but we could, all right, that's better, Thank you so much. You can proceed, Council Brand.
Isaac, I think I lost you for a moment there. Is my screen still being seen?
You can load it again. It went off. We lost you for a few seconds back. So you can reshare it again. Yes.
Okay, let me just do that.
Yes, you're back. You can just now do a slideshow to have your full screen. All right. Okay. Are you there now?
Not yet.
Okay. Okay, Council Brand, I think let's proceed with the earlier format because I think now? Yeah, it's okay. We can proceed with that. Yes, that's fine.
Okay.
Yep.
All right, thank you. So as I was just saying, very important is that you're prepared as a speaker because then at the end of the day, this is going to be seen throughout your submissions. It can be felt a person that is prepared definitely comes off differently from one who isn't. And I said that it really starts with a strong foundation that is backed up by, comprehensive research. And I think Juliana has really hinted on that more than enough, the imperative of comprehensive research. But also in trying to get ourselves prepared, we want to make sure that we know the facts and authorities, and I mean in and out. One of the things that many people like to take for granted is the fact that, since you have the record of the facts already, the problem question, maybe it's very easy for the judges to just flip over and know what you're talking about, but it's important that you leave your facts What that means is that you have to be very intentional about knowing each and every paragraph and line of your facts. I think it takes that level of meticulousness. You're very lucky that in this problem, you actually do not have very many pages to comb through. There are competitions where you have over 40 or so pages of facts, and you have to know each and every paragraph. So please know your facts in and out, that you can be able to cite a paragraph, a line, and tell the court what is therein. But also for the authorities, and again, this in a way touches the issue of impression. You want to own the case. And so when you're talking about an authority, know what the facts of that authority are, and also know where what you want to use lies. Be it the page, be it the paragraph. Know that if you're citing this case, you know when that case was decided and what the court, what the court pronounced itself on, the principles therein, and cite for Moot would do is that, one, we had sessions where as an individual, you have an obligation to go over your arguments. So be it before a mirror, wherever you are in your personal space, make sure you come to rehearsal sessions ready, but also with your teammates to practice. And in this instance, your teammates will still be playing devil's advocate. Do not just go for an easy ride. Don't be easy on each other. You should be able to be a devil's advocate during these practice sessions. And then also, still to tie back to what Juliana had said before, you want to know how you come off. And sometimes the best way to do this is by inviting a person who is not a lawyer, for example, to hear out your arguments, so that you can gauge and know if you're actually communicating or not. So you want to practice as much as you can. And with the community that we have of Mooters, it is also very important that you get some alumni, and I know people are usually very willing to help, to hear you out. So what I'm trying to say is practice as much as you can. And also to identify your strong points and weak points. You want to map those out, and you notice that in each and every moot court competition, definitely, there will be points that are either in your favor or against you. So you want to anticipate questions that will come, and most especially out of your weak points. You want to prepare answers of how am I going to wiggle my way out of a sticky argument. Go ready knowing an answer, that this is how I would canvas this question. So anticipate the questions and have answers for them beforehand. And some basics, really, you want to know how judges are addressed. The court you're before, is it my lord, is it your excellencies? Understand that for this particular competition, you'll be before the High Court. It's very simple to know that the people there are referred to as lords, or, so just do not call a High Court judge, your worship or your excellency. That won't work here. So know those basics as well. And moving on then, now when you get to the point of you're finally before the bench, I just wanted to underscore that the judges are your friends. It might not look so, but as you get in there, please have that at the back of your mind. The judges are your friends. They're here to help you get across your message. So interact with them on that basis. And just to go over what you would expect for a person, and especially for the lead counsel as you come up, your main task is to make sure that, one, you introduce your team, the issues before the Honorable Court, as well as how you intend to allocate your time. And after you do that, you also do well to indulge the bench on just, whether they need a statement of the facts. Because sometimes, and also depending on the level of the competition you're at, a statement of the facts might be relevant. And also, in you indulging the bench, it helps you in case they do not, in fact, want to hear the facts. That way, you save yourself some time. So I just quoted for you here an example. This is purely an example. It will be I was using this as a blueprint for what an introduction looks like. So this is a sample. You can always structure your introductory statements in your court. My name is Chira Brand, and I, together with Joshua Romo, will be appearing forward on behalf of the applicants, the unwanted witness. I will be handling issues 1 and 2 in 20 minutes, and my colleague will address issues 3 and 4 in 15 minutes. We shall reserve 5 minutes for rebuttal. Unless otherwise directed by your lordships, I will delve into the facts of the case in brief. Now, that is a sample of what an introduction would be. Thereafter, depending on what the bench has told you, you either go over the facts, and I really mean in brief, or you then delve into the issues that you have. And as Juliana said, as you give a brief of the facts, you want to structure them in such a way that they are in your favor, but again, they're not made up, because those are two different things. You don't want to gloss over the facts too much for it to appear as if you tell your story your way. The respondent will definitely also have a way that they can tell their story, and it makes sense that before, as a man, to take the judges along this trip to show us that in trying to persuade you so and so, I will be making argument A. And probably within this argument, I have 2 sub-arguments. One being that, blah, 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 and the second being this. You can also have space to make alternative arguments, and this usually comes in instances where you feel especially that maybe the judges haven't exactly been convinced or persuaded by your earlier arguments. It doesn't make sense for you to bring out an alternative argument in an instance where the arguments that you've made before seem to have been yes, and then be precise and to the point. The structure that has been talked about before, even in your memorial writing, that is the issue, law, applicability, conclusion, comes in very handy in you trying to achieve precision. We want to get to the issue, hint on the law, tie it into the facts, and then conclude, and then move on. There's always, there's a habit of oralists, especially when they're asked a question, to first go over, a broad arena of what the law is before answering, than just, getting to the specific law is relevant and showing us how it is applicable. And then when we talk about a judge, instances where a judge asks a question, it is very important that you stop speaking and resume only after the judge is done asking the question. And while you do that, you want to be courteous. And in fact, you stopping when they're asking a question is in itself being courteous. So stop when they ask, and after you can, for example, and I quote, say something such as, much obliged, your lordship, in response to your question. Then you go into answering the question. That is why I emphasize that, again, even when they ask, as I earlier on said, you want to be precise and to the point. And there are also instances, I'm just trying to draw scenarios that would happen where your
We lost you, Council Brian.
answer that much later. So please allow me to get to that. You don't want to do that. When it's asked now, please.
I think we lost Council Brian there. As we give him time to come back, please share your questions in the chat section. We'll be responding to them once he's done with his presentation. Otherwise, I'm reminding you to download the resources from the website. That is uw.moot.com. Yeah, let us download the questions and the resources. Council Brian? Council Brian? I think he's having network challenges. As Council Brian comes back, let me give chance to Council Alan Sempala to guide us on how to go to the website to download the resources, because I realize that some members are even asking for how to access the rules. All those things are on the website. Oh, Council Brian is back. Oh, Alan? Okay. You can take us through, Council Alan.
Now let me have him. Let Council Brian continue. I'll take them through later if he's back, if he's ready. Is he ready? Good. I just noticed that many of you don't even know where the question is. So this is the Moot website. It's called uwmoot.com. So you can go to about, and there you will get to know about the Moot, the organizers, and the partners. Then you can see what actually happened last year. Then under Moot 2023, there is the format of the Moot. We have the timetable, which is a schedule. It lists all activities that are being undertaken towards the final day of the Moot. So you get to understand which activities you keep track. If is Brian back? If he's back, let me stop here. I'll continue later.
Yeah, Council Brian is back. Council Brian, can you please proceed? Council Brian, please proceed.
Yes, sorry about that. I think you can now hear me.
Yes, we can hear you, Council Brian.
Yes, so as I was saying, I think at you lost me at the point where I'm talking about the roadmap. No precision when judge asks a question. No, answer a question when it is asked. It doesn't matter if you plan to answer that question much later in your argument, answer it at that point. And it also makes perfect sense for you not to get back to that issue much later at the point that you plan to answer it, if that makes sense. So if you plan to answer a certain question in your sub-argument 3 and it was asked while you're on 1, do not stick to the script and think that after finishing up with sub-argument 2, again go back to sub-argument 3 that you're. And also, while you're at it, please do be deliberate about pacing yourself. You really want the judges to listen to you, to follow the pace. Do not be too fast. Do not be too slow. And that is why I said you can even take a pause if you need to. Yeah, so pace yourself. And it's also important that you maintain eye contact across the bench, because the intention of oral submissions is to engage the entire bench. You want to be looking at each and every judge while you speak. It doesn't matter if a particular judge has asked a question. In answering, do not limit your eye contact to that particular judge. Still, make sure that you're looking across the entire bench, because at the end of the day, every single judge is grading you. And as you step up, make sure that you have somewhere where you note questions in case many are asked at a go. The last thing you want to happen is for you to think that you note all the questions in your mind, and then at the end, as you try to answer, you're asking. So that is the essence of having somewhere where you note the question, so that submissions. But
Yes, Councillor Brown, we lost you a bit. You can load again your presentation.
all right. Can you not see the presentation at this point?
Not yet.
Not yet.
Okay, can you try presenting without a video? Okay, it's coming now, it's loading. Yeah, it's finally here.
Okay, perfect.
Yes, Councillor Brand, you have about 5 minutes.
So what I was saying is maintain eye contact. Yes, maintain eye contact throughout. Have somewhere to note questions in case there are many. Referencing contemporary cases, that is also fine, but please do make sure that this is the last resort and then you're just trying to really convince and persuade the judges further. Also to say, remain of good cheer. Do not show frustration when under fire. We've seen this happen several times. And some oralists think that the judges are after them. It isn't the case. They're really helping you try to get to a certain point. So remain of good cheer. Do not snap. I know that sometimes some judges can really be hard, but it's part of the process. So maintain that composure. And also to say that be conversational while you're at it. You're talking to humans. They want to know you and they want to relate to what you're saying. So be very conversational, but also take it with a pinch of salt. You don't want to be overly familiar because, again, they are the judges. So just be able to tread that balance quite professionally. And while you're in moot court, it is consequential, is the law. So your opinion, there's been instances where an oralist will say, I believe, or in my opinion, that is irrelevant. You want to stick to what the law is, and please do not be speculative. We've seen a lot of speculation also, especially when it comes to areas of the facts. Some oralists like to fill in gaps. If something hasn't been expressly provided for in the facts, do not go about trying to extend the possibility of what could have happened. Stick to what you have before monopoly over knowledge. I know you've probably been told before that never, never at all admit when you do not know something, but that is wrong. It is okay for you to admit when you do not know the answer to something. And I know that lawyers always like to say, my lords have not addressed my mind to that. It's very simple. It's very simple. You can say that, and then the court will guide you if they want to anyway. It's much better than you lying about a principle, about an authority. They want to see that you care for what you're presenting, for what you're submitting, you care about the case. How this can come off is by you not reading your submissions. Coming to the last term with a bunch of papers that you're flipping over as if you're new. They do not expect you to read the data. I keep getting off. I think at this point I'll remove my video.
Yes, it's okay. You can remove the video, then you can have the slide.
All right.
Yeah, that will help us.
Permissions, what for what, and that is also provided for in the rules. So stick to that. If anything, if you really have to show up with anything, we always advise that you carry a small sheet that just has an outlay of how you intend to submit, what points you intend to submit. Otherwise, if you can, and you prepare enough, you could actually do E, and this spans from what you're wearing
Brian, Council Brian, could you please
share the screen?
Is it possible that we can, the Secretariat can help you share the presentation? At what level are you? Which slide are you on?
I'm really almost done with it, so I was actually just thinking I could go through it, but it's okay.
Okay, you have how many slides to go?
I have about 3 slides. No, actually 2, just 2.
Okay, then you can just, do it until we're done.
Yeah, so let me just finish those. I already talked about the issue of appearance. You want to be dressed appropriately, professionally. Please make sure that that is on point because you might not know, but the first thing that will happen when you step up is that, as is any human being, the way you appear to someone definitely creates a bias in their mind. So you want to appear smartly dressed. And your body language is also important. It is a key component of communication. So you want to know that do not look so uptight, for example, when you're up there, but also do not have your body swaying back and forth or sideways. You're distracting. If you have any hand gestures, try to have them limited. Try to, as if almost make them within the square that is just right in front of you. Do not have your hands moving all over. So body language is very, very key. When you're making emphasis, how do you motion it with your hands if you have to? That is also very, and also in terms of time management, you want to ask for more time if you run out. You can make reference to Article 33 of the rules. It's very instrumental in this. Do not just keep talking when you know that the court clerk has motioned to you that your time is done. Be courteous enough to ask that you be granted some more time to wind up with your submissions. And then one of the last sections is about the close rebuttal and sar rebuttal. Just to say that as you close at the end of your argument, you make your prayers, and then you relinquish the floor if no further questions are being asked by the bench. The rebuttal and the sar rebuttal, to draw some more light on this, these are made by the applicant and the respondent respectively. And at this point, it is important for you to know that you cannot introduce new arguments. So when you're doing your rebuttal and sar rebuttal, please do not introduce new arguments. Article 34 is very clear on that. And also for the respondent, when you are coming to make your sar rebuttal, please note that your sar rebuttal should be limited or raised by the applicant in the rebuttal. And then for the respondent, I thought it very important to say that as a respondent, it is very important that you listen intently throughout the applicant's submission. You're called a respondent for a reason. So please be able to listen and respond accordingly. It lies at the core of effective responding. You'll be wasting your time, and most times some judges will stop you if you start making arguments that were not raised by the applicants at all, unless you find that the argument that you have in a way is still relevant. If it wasn't directly touched upon by the applicant, then you can make it. So listen very intently. And then as I wrap up, I just thought it important to reiterate that judges are humans. You shouldn't forget that. So aim to impress, whether it's from your appearance, whether it is in your knowledge of the facts or the law, it is all part of impression. So be very keen on that. And lastly, know your rules. Know your rules. It is also part of the game, and particularly chapter 4 of the competition. It speaks to what you ought to do and what you ought not to do during the oral rounds. Otherwise, thank you very much, and I look forward to any questions or comments, and I wish all the teams a great competition and preparation.
Wow, thank you so much, Council Brian, for that wonderful presentation about the art of oral presentation. It's now time for questions and answers. We don't have so many questions in the chat section, which means that you've ably done the presentation. And I'm glad that surely the Mooters will not address the bench as sir, madam, and coming with cans of the courtroom. during the competition. Thank you once again, Council Brian. We remind you, please visit the website, download the resources. We won't stop doing this call. It's very, very important, but also follow us on our social media platforms. Our time is fast spent. Odiambo from Kenya, Derek, that is Congress School of Law, Kisii, University of Kenya. Thank you so much for showing interest to participate in the Moots. Please, next year, you will definitely be registered, but the step we are at right now is we've already closed the registration. So please, thank you so much for showing the interest. Without wasting any more time, I don't see any questions for Council Brian Kira. Let's just dive into our next session. That is looking at how we come from the moot court to practice. And these are just going to be live insights that are going to be done by Council Evelyn Mulungi and Council Elijah Enyemu. You're most welcome. I can see you already. Please, the floor is yours.
Thank you, everyone. I'm just trying to see how I can share my screen, so just give me a second. Just a second. Sorry, I'm having challenges sharing my screen.
All right. Are you there, Council Mulungi?
Yes, I'm here.
Okay, that's good.
Sorry,
that's good.
I'm having challenges trying to share my screen. So as I try to share my screen, I'll just be giving an overview of my background, and I think Elijah will also come in to give his background, and we'll be able to share the experiences that we've had. So first off, my name is Idlin Eva Murungi, and I am a practicing lawyer. I've been practicing law for some time now. I want to say when I started practicing, but some of you might start guessing my age. So we want to keep it simple and basic. And while I was in law school, I started in my first year of law school. I was very, quite frankly, bored with law school. I found it very basic: go to class, read, go read cases, then go do exams, give the first locus classicus, then give a contrasting case, and then do another exam, read another case, write another exam. Honestly, quite frankly, I was like, is this all I get to do in law school? And I remember at the time, I wrote a letter. No, I did not write the letter. My brother wrote the letter to Justice Julia Sebutinde, and I asked her, oh, I want to be like you. I want to be a justice at the ICC. How do I do that? And my brother mentioned that I was a first year law student. And I remember she vividly wrote down everything that I should do. And one of the things was do co-curricular things while you're in law school that are not necessarily books. And one of the things that I decided to do at the time was Moot Court experience. So that's how I became interested in Moot Court. Apologies, sorry, I always have challenges with Zoom and my laptop, and I'm trying to, okay, it's okay, I got it. And so at the time we tried to, I decided to become interested in Moot Court competitions. And so I remember my first Moot Court experience was the ICC Moot. And I have always worked, or Elijah has always been my partner in all the Moot Courts that we have done. And so, sorry, I'm trying to share my screen again, but I'm still having challenges. Apologies. Elijah, is it okay if you can take it up from here so that I can try screen sharing? After all, we have the same lived experience.
All right. Hi, everyone. Greetings. Elijah Nyumu is my name, and happy. I always get goosebumps whenever I hear about a moot, and I'm happy that Unwanted Witness, along with the other partners, is getting on board to prepare the second privacy moot. Like Idlin was saying, okay, Idlin is back. Idlin, do you want to continue or?
Yes, I can continue now. Okay, thank you, Elijah. Like I was mentioning, so a bit about the outline that we are going to do is we're both going to give a background of what we have done and the moots we've participated in, and then we'll move on to the skills that you learn from the Moot Court experience and lessons from the future and how that really plays out in practice. I think one of the questions that people constantly ask is, will this really help me? Am I wasting time? Will the skills I learn help when I move to practice? So I was still mentioning that the moots that we did, Elijah and I were Moot Court partners throughout law school. So his lived experience in terms of the moot competitions is my lived experience. So we started with the ICC Moot. This was around second year. And then, however, we stopped at memorial writing. I think at that point, we didn't advance to participate in the rounds in London. I'm not exactly sure why. I don't remember. That was the very first moot that we participated in. And then in third year, we did the IHL moot. We did national rounds. We were at Macquarie University. So we emerged victorious in the national rounds and then went on to move to the IHL moot, the same moot with the All Africa rounds in Arusha. Those ones that moot had all countries from around Africa. And then we did JSAP in 2015 national rounds. We were again the best in the national rounds, emerging best oral speakers, best oralists, and best memorial writers. Unfortunately, we did not have enough funds to make it to Washington. So we did not move forward to Washington. And then the year after, we went to LDC. And because we do not give up, we then did JSAP 2016. So we did both the national rounds, of course, emerged victorious. We had a great track record. And then we did the international rounds. And at the international rounds, you remember, okay, if you know about the JSAP, I think Juliana spoke about it. It's the most highly coveted moot competition. It has about, I think, 150 countries participating and thousands of mooters participating. So in those international rounds, we made it to the round of 32. So, and then from the round of 32, we beat the German team, imagine, and then we made it to the round of the octofinals, I believe. That's the round of 16, if I'm not mistaken. And from there, we did not make it to the finals. But we just did not stop there. We also won the Spirit of the Jessup. The Spirit of the Jessup is really, it's sort of I don't want to call it a trophy because they also give you money, but it's recognition for the team that best represents the Spirit of the Jessup in terms of how you've carried yourselves, how you've done your work, how you've written your memorials, how you have shown the Moot spirit. So you can imagine, of all the hundreds and hundreds of teams, we managed to win the Spirit of the Jessup. Now, I'll move on to the skills that we've learned from, sorry, I'm still on the skills. I'll move on to the skills that we've learned, especially from our experiences and how they have helped us in practice. So maybe a bit of a background about the work that I currently do. From law school, I moved to private practice first. I worked a bit with Bowman's, AF Mpanga, that's in Uganda. And then I moved, now I'm in-house. I'm working for a fintech company and I supervise East Africa. So I'm a regional legal counsel. Now, one of the skills that you learn is oral skills. Brian has explained how you have to speak in order to put your point across. And this is a skill that you're going to use for the rest of your life. It will help you in court. It will help you in boardrooms. This skill will help you in defending your clients. It will help you talking to all various sorts of people. Oral skills are one of those skills where no one is going to teach you how to speak. Even if you go to law school and you read hundreds of cases and you read hundreds of books and you start wearing specs and your eyes go blind, no one is going to teach you how to speak. You have to learn it. And Moot court is the best playing ground where you can make mistakes. For example, you can't make mistakes in private practice before your clients or before courts of justices or before people where you are supposed to come experienced. And in the legal profession, when you join private practice, no one is going to teach you anything. You just learn on the job. So law school is one of the best areas in which you can learn how to develop these skills. The second skill is discipline. Why discipline? Moot courts will teach you how to do things on time, learn how to work with teams, learn when to start and when to stop. For example, when we were doing the last Jessup competition that we did at LDC. LDC those who have had LDC is one of the hardest things that you can do as a lawyer. So imagine doing LDC and doing Jessup at the same time. We used to meet every evening after school. And then we would go over, we first did the memorials, then we did the oral rounds. And we used to meet every evening and go over when we were preparing for the oral rounds. And so Elijah would speak. Then if he makes a mistake, we're like, you're making a mistake, do it again. And our coach used to tell us that you're not going to leave until you have perfected your oral presentation. And I remember he vividly told us that think about this as a song that you created yourself. You know how we know all the lyrics to the latest song or to the latest music? You can sing that song from the beginning to the end. Or if you are a musician can sing that song from the beginning to the end. So imagine that this oral presentation that you've created for yourself, you imagine yourself singing it from the beginning to the end. So that's how we were able to sort of learn, but we had to be disciplined. We had to show up for trainings. We had to parade each other. We had to submit on time. You cannot win or you will not move to the other side if you're not disciplined. Yes, it's a bit uncomfortable, but growth is very, very uncomfortable. And if you want to grow and win and move to the other side, then you're going to be really, really disciplined. And then you learn to think on your feet. So again, I'll give the example of when we were in in Washington. So we reached the oral rounds of the JSAP competition, and we are against Germany. The Germany team had, first of all, they were so smart. Their suits looked like they cost, I don't know, $1,000. I don't even want to know how much those suits cost. And then they were very eloquent and elegant. And then the team was both male, and they had more points than we did. And what happens in the JSAP rounds is that when you proceed to the round of 32, the round of 16 up to the finals, the team that has more points in that particular round gets to choose which side they argue on. And if you've seen memorials or moot competitions, you'll also see this particular privacy moot competition. You'll see that the applicant side is usually easier to argue, because when they write the moot, that's what they have in mind. So the applicant side is usually easier to argue. The respondent side really is just loopholes in the case, or but it's never the one that has the easier route. So of course the German team chose the applicant side, and Elijah and I were on the respondents team. The team was made up of 4 people. So Elijah and I, as usual, were partners, and we were both the respondents. And so we had to argue that round, and our applicants had to sit out that round. They sit with you, but they don't argue the round. And when we came to that particular round, I remember it wasn't like how we used to do it in Uganda, where you have a premeditated script as a respondent. I remember the court vividly told us that as a respondent, you're only going to respond to the things that the applicant has raised. So if the applicant goes to speak and for some reason they run out of time and they do not mention certain arguments, you are actually not supposed to respond. You're stopped from responding to those arguments because the applicant has not raised them. It seems as if you're setting up your own question. So we had to think on our feet. You imagine you've had about 8, at this point you've had about maybe 6 sessions. So you know your song very well. You can sing it in your sleep, and you reach the round of 32 and they're telling you, you have to think on your feet. You're going to respond to what they mention. And I remember that was our best round. Honestly, for me, it was my best round. I did that round and I was like, oh my God, I'm a superstar. Like, where else? Like, nothing can top this. I don't care what I do else in my life, but nothing can top this. And I remember when we won that round, by the way, I could not believe it. I asked Elijah, like, have we won or are they mistaken? She was like, no, Idlin, we won this round and we are moving on to the octafinals. So it was very, very interesting, but I had to think on my feet. They were asking me questions like, the Moot is international law. So they would ask you questions like, oh, what was the professor doing in the country? And I'm like, that wasn't in the facts. How am I supposed to know what the professor was doing in the country? And they were asking questions as if I'm actually a representative of my country. So they would ask, why did you send the professor for the lecture if you knew that he would be arrested? And I'm like, okay, we sent him because he was the most qualified person and he had to go for this lecture. So I had to really get answers and think on my feet. Then the thing that also Juliana spoke about is writing and analysis. You don't just write. You have to write, think, analyze. And it really, really helps. This is a skill you'll take with you for the rest of your life. You're going to be writing papers, court submissions. You're going to be thinking for boardrooms or thinking for executives. And so you have to analyze situations in and out, poke loopholes. And this is a skill that you learn as well. I want to leave some time for Elijah since we have the same experience, but he'll also speak on his own part. Then the other thing that I really benefited is networks. Now, as someone who first of all, Moots helped you travel, but that's not why you should. I know some of you want to go to Mauritius, rightly so. But when we went to Washington, we met very good people. And there's this other team from Germany that we met, and we became very, very good friends. And one time I was traveling through Europe, And one of them told me, oh my God, like, so my, my status. And she was like, oh, you're in Germany. Why don't you come see us? And she mentioned that the other member of the team was having his birthday. So they brought me I had to go to Munich, and they took me as a surprise for the other team member. So when the other guy saw that I showed up in Munich, Germany, imagine, he was so shocked. He was like, what are you doing here? And he was like, oh my God, this is the best birthday surprise ever. And then these people are the people who will help you with, I don't know, master's applications, programs. When you start working, if they ask, do you know a lawyer in Kampala? They'll outrightly say, of course, there's Idlin. So there are networks that these are things that you cannot get from anywhere else. You can only get them from the Moot Court experience. And the last thing, honestly, for me, has been confidence. When you stand up in those Moot Court rooms, even if they are hypothetical, even if they are not real, the confidence that you gain over time, like if the ICC moots that we started with and the person who I was when I went to Washington, were two completely different people. And if you ask me, if everything else fails, then confidence will take you either places or will open doors for you. And that's something you will not find just sitting in a law classroom or just, I don't know, doing law school as a usual student. So the confidence for me that you get from the Moot Court experience is unmatched. It will be the confidence that will carry you through life, through any other thing that you may not even anticipate. It will be the confidence that will help you face senior lawyers in town when you're arguing a case. It will be the confidence that will make you call up a CEO of a bank and tell you, I'm calling you because I'm representing my client and we need this issue resolved. Otherwise, you might chicken out. So the confidence for me was the skill that I got from this. And up to today, I tell people, if I could go to Washington and almost win. Actually, I think we didn't win because we became tired. But if I could go to Washington and win, then there's nothing I can't do in my life. Like there's nothing that's impossible. So those are some of my skills. The next part is questions and then the thank you. So I think at this point, Elijah can come in and also give his experiences and the skills and the lessons for the future. And then we can all take questions at the same time. Thank you so much.
Right.
I'm going to keep the screen on, Elijah.
It is well. Thank you, Idlin, for that prelude and quite an exhaustive sharing. I'll jump straight into it. To the students that are listening to us, we were in your position at one time, and I would like to say you have joined, depending on how you perform, you have joined an exclusive club of mooters around the world. We are like the Freemasons, call it the Illuminati, whatever club you want to call it. And all law students are equal, but mooters are more equal than other law students. And I'm sure as you go through law school and your university, you would notice the lecturers and your fellow students are going to give you different type of treatment based on the fact that you are a mooter. When you continue to the national rounds or international rounds or whatever moot it is, there is more respect that is added to your name when they speak about you in corridors. So join this opportunity with all the strength and zeal that comes with it. And I would like to also emphasize, like Idlin has done, that a man with an argument or a theory is no match for a man with an experience. So you that are going to get the experience to moot, to appear before a panel, to actually argue a case, to actually defend a case, are not going to be equal or even compared to your fellow colleagues that are sitting back and are going to be watching you from the gallery. So the experience that you'll get from Moot, Idlin has spoken about legal writing. Most of you after school or even during your clerkship and internship, majority of your assignments are going to be legal opinions and writing legal memorandum for advice to clients. The skills for legal writing begin from moots like this. So you are given a problem. Most times the partner will not give you the actual details that come with the case. They will simply tell you what happens in a scenario where a client comes with X, Y, and Z, and they will expect you to make a legal opinion. So the skills you get from hypothesizing cases and giving advice based on the hypothesis is one that is going to stay with you forever and ever. Number two, Idlin has also spoken about time management. I will emphasize that as lawyers, increasingly nowadays, when we appear before panels, when we appear before tribunals, when we appear before courts, we are given limited time to do highlights of submissions or actually make the actual submissions. You'll find some judges at the commercial court literally tell you, counsel, you have 10 minutes, address me on points X, Y, and Z, and you must finish the submission in that time. Same thing happens at the Court of Appeal. We had an election petition in 2021, 2022, and the judges said we have 8 appeals lined up for today. Counsel, each of you have 10 minutes to actually address us on an election petition appeal. So I don't know how many polling stations you're going to cite in 10 minutes, but the ability to succinctly make an argument and make your point addressed in the shortest amount of time is a skill that you get from Moots. From your rules, you will notice that you are given a limited amount of time to address 2 or 3 issues as an orator. So you might not have the luxury of speaking for 30 minutes like we have, and you will have to do it in 12 minutes. Yeah, for us, we always practiced, if you have 15 minutes, practice to do the submissions in less than 11 or 10 minutes and leave the other 5 for disturbances, questions, or even a moment where you might have stammered or you might have gone off course. Increasingly also, you'll have to deal with what they call preliminary objections. Juliana spoke about them, I think also, and Brian. So preliminary points of law are not prepared for. Most times, if you're the respondent, you are going to be shocked in court by the preliminary objection. And you'll always say counsel should not be ambushed, but this is mooting. This is going to be practice for you. So if there is a preliminary objection you had not foreseen and it is raised, you are expected to deal with it there and then. Number 3, most of your employers are going to ask you, how well do you work under pressure? Mooting is pressure. I'm sure many of you now that are on the Zoom call are already panicking as is. Shall I manage? Should I do all these tasks? How about my school? Perhaps coursework is around the corner or final exams are around the corner, but being a mooter is strictly pressure. Being a mooter is dealing with uncomfortable situations. Being a mooter is long hours. Being a mooter is spending an extra mile to just simply do that one activity. So as you go through practice, you'll notice that there are days you are going to leave the farm at 11. There are days you're going to leave the farm at 10. You'll have to work over weekends. You'll have to work over on Sundays. And that is a lived experience that you're going to start as mooters. As all of us are going to be celebrating Labor Day, I assume most of you are going to be going through the materials that you are going to download from the website. So part of mooting is extra sacrifice. Part of mooting is going the extra mile. So do not be deceived. The person that is most prepared is the person that actually wins the moot. Yeah, so if your colleague has read more sources than you have, believe me, he's going to have a better memory than you have. If I've read more sources of law than you have, there is no way you are going to make a better submission than I have. So please, we kept saying there are 3 P's to winning a moot: prepare, prepare, and prepare some more. Yeah. So between now and July, is it, when you're supposed to file your written memorials, please prepare as exhaustively as you can. The same skill comes over to practice. You have to anticipate every witness that might come along the way. You have to anticipate any question the panel might ask you. You have to anticipate what questions the judges might address to you, and you have to work in all of that under pressure. So here in the moot, the pressure is representing your university. When you come to practice, the pressure is going to be the client. Here, it is simply representing your school or your teammate, perhaps, but when you come to practice, you are carrying a country, you are carrying a whole department, you're carrying a whole company on your shoulders. So the pressure and confidence and the ability to represent someone ably that you are going to get from this process is going to help you carry on to actual practice. Then finally, on my part, I would say mooting begins with hypothetical questions, and increasingly nowadays in the human rights field, and in the specialized practice areas, we begin with hypothetical questions. Fortunately, one of the team of Unwanted Witness and Brian, we have been on what they call case surgeries. Case surgeries are hypothetical scenarios we go through before we file an actual case. So the skills we got from addressing hypothetical situations in moots help us today when you're dealing with case surgeries. And I wouldn't be surprised if unwanted witness filed a case concerning the number plate issue or filed a petition in the High Court concerning human rights enforcement that is going to arise from the Moot. Juliana works with the Law Reform Commission, and part of that arises from hypothetical situations. What are we doing that could possibly affect rights in the future? So the Moot that you're addressing today, perhaps the arguments you'll make, the memorial you will make, will help in preparing for the human rights case that will come along if the number plates are actually put into force. Then painting a picture. Mooting and practice are simply painting a picture. Yeah, how convincingly you can paint a picture will determine if you win or lose a case. Yeah, if you are the applicant in this case or the petitioner, you must be outraged by the fact that they are trying to track number plates. Yeah, make noise, please show the emotion. If you are a respondent, come and make it seem like these number plates are actually for the benefit of the security of Ugandans. Yeah, or the people of, in this case, it's the people of Uganda. So mooting and practice is about painting a picture. Yeah, an employee has lost a leg, you come and argue it in the form of negligence. Yeah, if you're representing the employee, you are arguing the man's life has been changed forever. So the ability to paint a picture is a skill that you develop now in infancy as a law student, and it is going to carry on up to your final practice. The Makdusman Kabegas of this world and the Mpangas of this world are masterful storytellers. And that is your work as a Moot. You are telling a story, you are painting a narrative. Yeah, so please, whatever side you are on, you have to actually have a narrative for both scenarios. Yeah, so they say the test of intelligence is the ability to have two diverse opinions and harmonize in one head. So I'm sure you're going to have an opportunity to argue as applicants, then you're supposed to flip on the other side and argue as respondents. Sometimes you'll even appear before the same panel of judges and they'll tell you, but counsel, one of your colleagues referring to your own argument as applicant argued X, Y, and Z. You must have the ability to see it from both vantage points. Same thing in practice. Today you represent the company, tomorrow you represent the employee. Yeah, we have seen scenarios in practice where you defeat a client and he says, I think I want you to start representing me now going forward. So that is an ability you develop as a motor to argue both coins, both sides of the coin, and have them in one hand. And for the future, I personally have used mooting to earn me some money. I have been a judge on a couple of moots, and some of them have paid very decently. Number two, my first entry into lecturing at a university was because I was a moot instructor / coordinator. Then finally, also, the moots have opened, Idlin has said, networks. I got instructions from a colleague in Kenya because we met at the moot in Arusha. I've had people in Nigeria help me do research because their country is addressing something that we have not yet dealt with in Uganda, and their cases have addressed the same. So the connections and the possibilities that come from mooting are immense, they are diverse, and they'll give you options for what areas of practice to approach. I have done some human rights litigation, and all of us are arisen out of the love and experience we gained from mooting. So to you that is joining today, to you that is maybe questioning, should I get in or get on board, please jump on this with both hands. You have to claw, you have to cry, you have to suffer, you have to go through pain simply to have the honor and great privilege of being a mooter. And this is a society for life. Juliana, Brian, Idlin, and all the other mooters from different universities, we actually know each other. We are like a small cabal. So once you have earned your stripes, like they say, your ranks are forever. Yeah, so, and we'll keep meeting, and the respect you get from one moot is always carried on throughout, actually. So please, we urge you to join and jump on this with both hands, and all the best to you. Back to you, Idlin.
Thank you, Elijah. I think we've exhausted everything. Oh yes, maybe the one thing that we have left out is that mooting will help you with school. And some of you might think that school right now is very complicated, but once you do moot court competitions, and then you learn all these, the skills you're going to learn between now and July. If, for example, you're still in second or third year, you're going to see the difference between your grades in the next couple of years, because you're now going to think differently. So mooting is definitely going to be helping you with school, and it's also going to help you if you want to do further studies. I am a living testimony. Liz said that I have to mention this, and indeed she's very correct. I managed to do my master's in law at Harvard Law School. And yes, some people might say I had good grades, but I will also say that my grades in third and fourth year were exceptional because I had moot court experience. Exceptional because I knew I would read a problem question in class and I know exactly what I'm supposed to do. I'm supposed to analyze, I'm supposed to give a contrary case. I knew exactly what I'm supposed to do because I've done harder things. So it might be hard for you now, it might be complicated for you now, but it is going to make your life as a lawyer so much easier. Like Elijah said, we are in a league of our own, no one can compete with us. And then even when you're going for your master's studies, I think 80 of my master's class had moot court experience. And the reason is, as a lawyer or as a law student, what else have you done? If we were in primary school, you know how they used to ask us for co-curricular activities? You would say, yes, I was in the debate club, or I was in the patriotism club, but there is no debate club at law school. The closest you come to debate club or patriotism club is participating in moot competitions. And so this is the co-curricular activity that your master's schools are going to be looking for that you have done. Where has she been? What has she done? So if you're not going, if you're still thinking, I don't know if I want to do it or not, please do it. Because once it's on your CV and once it's on your, you know, like you show, I did this moot competition and this is how well I did, then it automatically puts you in a class apart from everyone else. When people are admitting students for master's programs, they usually want to see the thing that is not law. I'm not saying you shouldn't get good grades, you definitely should, but everyone else wants to see what else are you, what full package do you present? How are you going to give back to your country? And the last thing that Elijah also mentioned is the judging. For you to actually now move to the other side and become a judge, you have to live the experience, and you won't become a judge if you don't participate in the moots now while you're still a student. So I think since I went for my master's, while I was doing my master's, I was able to judge. I was a coach for the Harvard team. And then when I moved to New York, I was a judge on the North. So in the US, they divide the moot courts into 4. I was a judge for the North, like the Northwest region that has Harvard, Columbia, Yale. So imagine that privilege of being in that position. Like Idlin, I was judging Harvard students. I could never have done that if I hadn't started all the way from my first, second year of law school. I think those are the lived experiences and lessons that we have.
Wow.
And we are very grateful that you've given us a platform to speak. Thank you, Elijah. It's every time I'm with Elijah, I'm like, this is how we've always been. So Elijah and I have been teammates. So I hope one of you is able to get a teammate from this moot that you'll also move with. That's the other experience that you should get from here. Like every time people contact Elijah, he's like, oh, where's Idlin? We come as a package deal. So this is how we've been rolling since second year. It's been almost 10 years. So yeah, it's been great. We ready to take any questions.
Yes. Okay. Wow. What a wonderful way of ending it up. You wish that from these motors, at least somebody gets a teammate that they can move with a journey like you have moved with Elijah. Wow, thank you so much. That was very vast experiences from Edlin and Elijah. I know we have a question here. As a colleague of Edlin and Elijah, I can't testify to both their tiresome efforts in the Moot process while at law school, but mainly the unequitable benefits, the unquantifiable benefits they have obtained from the Moot to date. They are good authorities in Moot. I think we agree with you there. That has been a comment put into the chat session. Thank you so much, Councillor Edlin and Elijah. You've said it all. Mooting is about pressure, going an extra mile, extra sacrifice. So this is what it calls for. Thank you indeed. And I trust that the Mooters on the call on this meeting can appreciate that Moots can make you move places. How you leave Uganda, go and win in Washington is just so amazing. Thank you so much. Let me give Councillor Alan some time again, about 5 minutes, just to take us through how we can download the question, the resources from the website. Then I would go into our final presentation of the tally. Thank you so much.
Thank you, Isaac. Thank you, Councillor Elijah and Edlin. Certainly, yes, you can't get anywhere without being part of Moot. So Moot should really be the first step for you. It should feature on your CV really. And what better way to even get a privacy job if you've ever participated in the first privacy Moot on the African continent. Wow. The unwanted witness privacy Moot competition now. When you go to the website, quickly, let's get to this. When you get to the website, go to Moot 2023. Here you will get the format, you will get the timetable, you will get the boot camp and everything concerned with the boot camp. What are the objectives and what exactly, why the intention of holding it. The Moot rules there, the regulations, please download them, click on them, download them, read them, understand them. But it's they have guidelines on how you write your memorials, how you submit your orals, how you conduct yourself, you know, all through the competition. There you will see also the privacy policy for the Moot. We have a privacy policy for the Moot. We have a code of conduct for judges, which all judges that are going to be adjudicating over the competition will sign those that code of conduct and you know and abide by it. We have a code of conduct for the Mooters as well. Then we have the participating universities there and the team codes. Now here, those who are asking where to get the case, when you come to the case, there is a drop down. You have the Moot case here, you can click it, download it, it's a PDF file, download it, save it on your computer, and thereafter you can print it out. Then the Moot resources, these Moot resources certainly will guide you on where to get information and how you go about with your research. So pretty much that's how you can get the question and how you can go about the website. Otherwise, thank you very much for your time. And I hope you've benefited from the submissions, from the brilliant submissions, from the, you know, from the mouth-dropping experiences of Edlin and Councillor Elijah. So over to you, Mr. Matovu.
Yes, thank you so much, Councillor Alan, for that. Please, let's go download the resources. Let's go download the question. So according to our program, we have about 20 minutes before we can conclude this call. Allow me take you to our next presentation. That is about the tally. Okay, are we there? Are you able to view the screen? Okay. Yeah, so this is the tally center system. We know this involves so many scores. Myself, Matov Isaac Ismail, I'm doing this, and I want to take you through this very fast, how you're going to be able to to get to the winning team that will be able to move places, as we heard from Council Edlin and Elijah. But also, as you heard that, yes, a team is going to be traveling to Mauritius this year. So very fast, we are looking at the categories of awards. You can refer to chapter 6, article 42, where we have all this from the rules. That is the overall champion. We'll have the first run-up. We'll have the best oralists. We'll have the best written submission respondent and best written submission applicant. When you look at the scoring, we'll be doing the scoring for the structured memorials. That is from chapter 4, article 24. Memorials for each team will be anonymously judged and scored by 2 judges. The 2 memorial score for each team is the accumulated average score by both judges for both applicant and respondent memorial minus any penalties. The scores are rewarded out of maximally 100%, where we'll look at these parameters. All this is very clear in the rules. We are going to be looking at the knowledge of the relevant laws and facts and relevant principles at 25% there. Organization, structure and analysis of the issues, that is also at 25. Then use of authorities and citation, we've heard from Council Juliana and how all this is going to be computed. Then persuasiveness, ingenuity, logic, and reasoning. So these are the parameters we are going to be looking at in there. And the score sheets will be as follows. So it would be marked out of 100%, is what I've been explaining. So each judge will have to make a comment of each team as applicant, but also as a respondent. That is regarding the memorials. Then when it comes to the scoring of the all rounds, we shall still score that by 100% when you refer to chapter 5, article 38 of the rules. Then also we have the allocations as structure and analysis of issues at 25%, use of facts and legal principles at 25%, use of authorities and citations at 15%. Then also the persuasiveness, the logic, presentation, reasoning, 20%, and then the courtroom etiquette. Council Brian ably took us through all that. Your dress code, your presentation, all that will come in the 15%, 15 points, all to add up to 100%. Then that will be the form. Still, the judges will score each university with your own code, but also will score each individual, each Moota as an oralist. It's from there that we'll be able to have the best oralist. Then, of course, the oralists will have the best oralist respondent and best oralists applicant. Key points for you to note here is that both written memorial scores and oral score contribute to the final score, right from the primary round up to the final round. You can get more on that still when you refer to chapter 3, article 12, part A, and article 13, part A, and article 14, part A, that your scores will be determined from both your written memorials up and the oral scores. But in the event that there is a tie, what will happen? Still, all this is provided for in the rules. Okay? Right from the preliminary rounds up to the finals. when you look at Chapter 3, Article 13, Part B, that is at the semifinals, the winning team will be determined based on the team's overall memorial scores and further evaluation by the judges following which the decision shall be made. But also at the final, that is under Article 14, the team with the highest total score in the written phase of the preliminary round will proceed to the overall champion. And Article 14 also provides for the fact that the final decision shall be made by the judges. So in a nutshell, that's how the tally system is going to work for the Moot. And we'll be sharing the results for each university after the Moot via email. And we'll also have certificates for participants of attendance right from each person who participates up to the finals. So basically, that is it. I'm going to be welcoming Chris. We've had very good testimonies here from Edlin and Elijah, but we also have a short video here to share with you from our winners from last year. That is our best oralists from KIU. Chris, are you ready? Yes, let's have Chris share with us a video.
Good morning, members of the press. You're most welcome to this press conference. Unwanted Witness, together with the Public Interest Law Clinic at Makerere University, are organizing the second privacy moot court competition. So this year's privacy moot court competition will take place between the 21st and 22nd of September 2023 here at Makerere University at the law school. And the theme of this year is balancing privacy rights and national security, navigating the impact of surveillance laws to individual freedoms, particularly in the context of surveillance laws. We all know that you have the surveillance laws that exist in this country. For example, the Regulation of Interception of Communications Act, which enables the tapping of our calls. But also we have a data protection law that equally protects, but also has provisions that gives leeway for surveillance for purposes of national security. We are also going to have car trackers embedded in our cars. These trackers are going to collect data. So what happens to our data as government enforce their mandate of providing security to the nation? So this gives an obligation, to government as they promote the issues of development, and the technology is one of those development issues that we are looking at today. So we therefore encourage all law students with an interest in privacy law and protection of personal data to register for the second edition of the Unwanted Witness Privacy Moot Court competition.
Unwanted Witness came at a time when we were actually looking for partners to help us with our moot competitions, because a moot competition is really a method of teaching where students are given a question. The question is normally hypothetical. The students go and do a lot of research and practice, and they appear or they simulate an actual court trial. What is special about this particular moot is that these students are mooting before practitioners, before experts in the area, before previous mooters, but the finals students have an opportunity to moot before real judges.
The theme is balancing national interests with private interests in regard to privacy. So the students have to be able to argue the hypothetical question on the side of government protecting national interest, and also on the side of private individuals who expect the right of privacy to be respected. So from this year's Moot, I expect that the students will be better prepared, that they'll be able to identify the issues, the critical and salient issues that are raised in the Moot question, that when a judge asks them a particular question, they will not look blank, they will not know which law they are supposed to refer to, but they will know the law. And I've also been informed that there is going to be a bootcamp training for the participants who are going to enroll to take part in the Moot. So I expect that they will learn a lot from that training. So by the time the September comes and the Moot is taking place, before the practitioners like me in the preliminary rounds, and then before the real courtroom judges, High Court and Court of Appeal, they will be well-versed, they'll be presenting as if they were real practitioners in a courtroom.
I have also had the opportunity to read in the problem of this year, and it is equally that challenging. So to make research about a developing field of the law was challenging, but also interesting. I got the opportunity to learn of a lot of jurisprudence from the European Court of Human Rights on data protection. And for me, that was both educative and challenging. And also, like you have also heard that we appear before advocates that are practicing, for example, Judith Aboto here, and also before judges of the High Court and the Court of Appeal. For example, when we are in the final, we appeared before His Lordship Stephen Mubiru and His Lordship Justice Chiriabwil of the Court of Appeal. And for me, that was thrilling and exciting and very much humbling as a student of law, not even a practicing advocate, to appear before such senior judicial officers was very good.
Today, you are most welcome to this day.
The High Court of Uganda, holding at Makerere, civil suit number 3, Lensley Glynn versus Kapo Border Limited and X Company Limited. The counsel for the applicant in this matter is UW 0422. And the counsel for the respondents in the matter before this honorable court is UW 0622. Court session begins.
Your Lordship, we appear before this court by virtue of Article 50, Clause 1 of the 1995 Constitution of Republic of Uganda as amended, as well as Section 3, Subsection 1, and Section 4 of the Human Rights Enforcement Act of 2019.
My Lords, under Section 33, Clause 2 of the Data Protection and Privacy Act, it is a defense that is provided by the respondents to show that if they carried out reasonable care to comply with the provisions of the Act, then they should not be found liable or be found in breach and sanctioned for non-compliance.
The actions of the respondents, that is Kapo Border, were against the minimality principle established under Section 14 of the Data Protection and Privacy Act of 2019.
My Lords, I wish to bring to the attention of this court that the applicant proceeds under Section 33 of the Data Protection and Privacy Act. This act states categorically, my Lords, that in order for one to get compensation, there must have been damage or distress. The mere allegation that a right has been violated does not warrant compensation or any other remedy.
I take the opportunity to thank you, Your Lordships, for according us this opportunity to close the inaugural Unwanted Witness Privacy Moot competition, which started yesterday with a team of 8 universities. I'm delighted to be here today to officiate at the closing of the final Moot competitions that have been hosted by Makerere University. This maiden inter-university Moot competition on privacy
organized by Unwanted Witness, is a great stride in building capacity for future privacy defenders and practitioners.
My lords, Vice Chancellor, ladies and gentlemen, on behalf of the School of Law, Makerere University, with whom we have co-organized this inaugural Moot, the partners, the Unwanted Witness, we want to thank you so much for having considered our school to organize this event. We don't take that for granted.
Wow, thank you so much. That has been a highlight of what transpired last year in our first privacy Moot court competition 2022. We have just about 3 minutes before we can close this meeting. I want to thank you so much for participating, and I want to welcome Council Alan Sempala to give us the closing remarks on behalf of Unwanted Witness, the organizers.
Thank you very much, Isaac, and the entire Secretariat, our facilitators, the PDPO office, and the PILAC. We really thank you for being part of this. It's been such an amazing experience. I'm certain that each one of us here as participants, the Mooters, you've surely gained from the experiences of those who have mooted before. You've gotten insights on what the question is all about. You've also been pointed to the right direction on how you should go about with your oral submissions and your written memorials. You know now where to get the Moot question. We've taken you through that. You go to the Unwanted Witness, the Unwanted Witness Privacy Moot website, which is uwmoot.com, and there you'll find all necessary information and resources to help you start. Be notified that the deadline for submission of your memorials, written memorials, is 30th June. So you have close to 2 months and a few days to do that. 2 months might seem such a big time, but if you know what research means and coming up with the right information, you certainly know that you actually don't have so much time to come up with the winning memorial. Like Isaac took you through the Tally Center, the memorials play a big part to your final mark. So give it time, give it the required energy, give it the required effort, so you could score very well in your memorials. Because where we have a tie in your oral marks, regard will be given to your written submissions on how you performed. So therefore, I thank you very much for coming. I remind all of you to please follow us on our social media handles at for the privacy Moot, like, follow, and so you could get updates on what's going on. We'll keep giving you, tips on how to go about your memorials on our social media pages. But please be reminded that the winning duo will be traveling to Mauritius, Port Louis, for the African Privacy Symposium. You definitely don't want to miss this chance. So that should motivate you enough for you to put in enough effort so you could have an opportunity to attend the biggest privacy and data protection platform at the African continent. Thank you very much for your time. May God bless you. May God bless Uganda.
Wow. Thank you so much, Council Alan. our meeting has come to an end. We wish you the best, and everyone is a winner when it comes to the unwanted witness privacy moot court competition, because with a trophy you go with, but also you go with knowledge. God bless you all, and see you